in April 2019, Supreme Court declared February 12, 2018 circular as unconstitutional, and after it is declaring unconstitutional on June 2019, RBI unveiled a new revised framework in June. Now this can be a potential question. On June 2019, RBI came with a new circular by relaxing several provisions in the earlier circular. So what all relaxation it has done, we'll see that. Okay. So I'm just revising. Okay. February 12 circular, what it was having, it will label an asset, okay, as a non-performing asset if it is missed repayment even by a day. So within that 90 days, within a day, it will be considered as NPA, and it will be given a deadline. What is the deadline? Timeline. Within 180 days, you have to find a resolution. If you are not able to find 180 days, then it will go to the insolvency and bankruptcy court, or it will go to the bankruptcy court. It will start the insolvency proceedings. Okay. Now, what is the major reason for the why February 12 circular have been said unconstitutional by RBI? Because it said that this one day default recognition was the major con. Within 1 day, you have given, means once it has become an NPA, next day itself, you have 180 days time limit is there for resolving, or within 180 days if you can't resolve, put under IBC, go to the bankruptcy court. Okay. So, this forced resolution, this is a forced resolution through IBC, and finding a solution through a time-bound manner have been declared unconstitutional by Supreme Court. Okay. Now, what is this revision? Now, we'll make a comparison. February 2018 circular and June 2019 circular. What is the revised and the new revised norm? Okay. What is the new norm and the earlier norm on resolution of stressed asset? Okay. Now, earlier, bank has to refer borrower to NCLT. NCLT means that is starting of bankruptcy proceeding, bankruptcy court. NCLT is the major for if a corporate default, okay, or to start insolvency proceedings, it have to refer to NCLT. I'll discuss in detail in the bankruptcy class. Okay. So, bank have to refer the borrower to NCLT or bankruptcy court if it failed to resolve the account if the resolution of the account is not possible within 180 days, it will refer to bankruptcy court, or what is that bankruptcy court? National Company Law Tribunal, NCLT. What is the now condition? Lenders is given the choice. Earlier there was no choice. You have to, once it is default, within 180 days you try to resolve it, otherwise submit your plan, resolution, insolvency proceedings to NCLT. Here, lenders will be given the choice to initiate legal proceedings for insolvency or to go for recovery. So, the choice has been given whether to go to insolvency proceedings or to recover. Okay, so choice has been given, not compulsion. Second here is the stress asset. Earlier, the stress asset norm was applicable only for banks. In the earlier thing, this earlier stressed asset norms was applicable only to banks. Now it is wider. It is applicable to banks, small finance banks as well as NBFCs. This is very important. Okay, so wider means it is applicable to banks, small finance banks as well as NBFCs. Default of even 1 day has to be reported and acted upon. In the case of earlier regime. Now instead of 1 day, it has given, lenders have given 30 days. So earlier it was 1 day to act upon, to report and act upon, means the day it has become an NPA. Now instead of 1 day, it has given, lenders have been given 30 days to start working on a resolution plan from day of default. Okay. So regarding the resolution plan, earlier there was only 1 day, now it is 1 day have been increased to 30 days. So the number have been increased to 30 days. And then agreement, earlier it was said that all the lenders was required, agreement of all the lenders was required for implementing a resolution plan. Earlier, and that was very practically difficult. Agreement of all the lenders means all the lenders coming together saying, see this law is applicable to which type of firms? loan having 2000 crore and above. So there will be more than one lender. All lenders accepting a resolution plan is quite practically difficult. But what is the new says that agreement is not required from all the lenders. Agreement of 75% lenders by debt value. Debt value 75% of debtors by debt value, 75% of lenders by debt value, and 60% lenders by number. So imagine 10 lenders are there. 10 lenders are there, and each lenders might have given different loan amount. Na? So 60% by number means 6 out of 10, 6 is approving, and 70% of the value of the loan amount, 75% loan amount, then it can be approved. Resolution plan can be approved. Okay. So this is the key thing you need to what RBI have done. RBI have revised in relation to the earlier one. This is February 2018 circular. This is June 2019 revised circular. After Supreme Court have declared it as this one as unconstitutional. Have declared it as unconstitutional.